Hello. Welcome to A Kenya Law Explained, the podcast where we dive deep into the laws that shape our daily lives in this nation. Today, we are tackling a topic that's become all too common in our digital age: privacy invasions through filming and online sharing. Have you ever wondered if it's illegal to film someone without their permission? Or to post that video online? What rights are at stake, and which Kenyan laws protect us? And if you're a victim, what steps can you take to seek help? This is about real people, real stories, and real protections. We'll break it down step by step, exploring the topic, sharing examples, and even delving into historical context to give you a full picture. So, is it illegal to film someone without permission? The short answer is: it depends. But don't worry. We'll unpack this thoroughly. The act of filming itself isn't blanket illegal in Kenya. But it's heavily regulated by context, location, and intent. Our starting point is the Constitution of Kenya, 2010, which is the supreme law of the land. Article 31 guarantees every person the right to privacy. It states every person has the right to privacy, which includes the right not to have 1. Their person, home or property searched. 2. Their possessions seized. 3. Information relating to their family or private affairs unnecessarily required or revealed. And 4. The privacy of their communications infringed. This article of the Constitution forms the basis of privacy protections, and filming can easily infringe on it if done without consent, especially if it captures personal or intimate moments. Now, let's distinguish between public and private spaces. In public areas, think the busy streets in Nairobi like Kenyatta Avenue or Uhuru Park. Filming is generally permissible without consent because there's a lower expectation of privacy. Kenyan courts have recognized that in public, people can't reasonably expect total seclusion. For instance, in a 2019 case, Njoki Kumina vs. KTDA Agency Limited, the High Court emphasized that even in public, using someone's image without consent for commercial purposes violates constitutional rights to dignity and privacy. So, if you're filming a crowd for a documentary or news, it's often okay, but zooming in on an individual and capturing identifiable details like their face, tattoos, or actions could cross the line if it invades their personal space. Contrast that with private spaces. Your home, the private event, or even a semi-private area like a restaurant booth. Here, filming without permission is almost always a no-go. It directly breaches Article 31 by unnecessarily revealing private affairs. The Data Protection Act, 2019, DPA, which we'll dive deeper into later, treats images and videos as personal data if they identify someone. Under Section 25 of the DPA, personal data must be processed lawfully, fairly, and transparently, which typically requires consent. Without it, you're violating the law. But what about intent? If the filming is for malicious purposes, say, to harass, blackmail, or humiliate, it escalates to a criminal offense under the Computer Misuse and Cybercrimes Act, 2018. Section 37 criminalizes the wrongful distribution of obscene or intimate images, even if not yet shared. For example, non-consensual recording of intimate content, often called revenge porn or cyber exploitation, is a serious violation. Advocacy groups like FIDE Kenya have highlighted cases where victims face emotional trauma, and perpetrators can face fines up to 200,000 Kenyan shillings or 2 years in prison. Let's think about real-life scenarios. Imagine you're at a matatu stage in Nairobi, and someone films you arguing with a conductor. If it's in public and not invasive, it might be legal. But if they capture your face clearly and use it to mock you online, it could infringe on your dignity under Article 28 of the Constitution, which protects human dignity. Content creators, take note. The Office of the Data Protection Commissioner, ODPC, has issued guidelines requiring explicit consent for non-participants in videos, especially if sensitive info like location or behavior is revealed. Historically, Kenya's privacy laws evolved from colonial-era protections, but the 2010 constitution marked a turning point, embedding privacy as a fundamental right amid growing digital threats. Before the DPA, cases relied on tort law or defamation, but now, with smartphones everywhere, filming disputes spike. In 2023, the ODPC reported over 500 complaints related to unauthorized recordings, many from social media influencers filming strangers for pranks. The lesson: always err on the side of consent. If you're the one filming, get verbal or written permission. If you're filmed, know your rights. More on that later. Is it illegal to post it online without permission? Moving on to the second question. What if the filming leads to posting online without permission? This is where things get even stickier, and yes, it's often illegal. Posting a video or photo online without consent amplifies the privacy invasion because it disseminates personal data to a potentially global audience. Under the DPA, sharing images counts as processing personal data, then Section 30 requires explicit, informed consent unless there's a legitimate public interest, like journalism. Without it, you're liable for fines up to 3 million Kenyan shillings or 10 years in prison, especially if it involves sensitive data like health, ethnicity, or intimate details. The Cybercrimes Act adds teeth. Section 42 criminalizes unauthorized sharing of personal data, then Section 37 targets intimate or obscene images, with penalties including fines of 200,000 Kenyan shillings or 2 years imprisonment. Recent cases, like the 2026 outrage over viral TikTok clips of women being approached without consent, highlight this. Capital FM reported that such acts violate data protection laws, sparking debates on digital ethics. Even in public filming, posting requires caution. If the content humiliates or exposes someone. Think a video of someone in a vulnerable state, like intoxicated or in distress. It breaches dignity and privacy. Facebook posts from users like Sami O. Ngea emphasize that under Kenyan law, posting videos that embarrass or harm dignity is illegal, citing the Constitution and DPA. For influencers, the Kenya Film Classification Board, KFCB, warns against sharing inappropriate content, with penalties for misuse. Examples abound. In 2022, a viral video of a person in a private moment led to a lawsuit under the DPA, resulting in content removal and damages. Or consider CCTV footage. While usable as evidence, sharing it online without consent can lead to fines, as per ODPC guidelines. The rise of social media has made this a hotspot. Amnesty Kenya notes privacy is under strain in our digital future. To avoid liability, creators should anonymize, blur faces, or get consent. Victims demand removal. Platforms like Facebook and TikTok have takedown policies aligned with Kenyan law. Which rights are being protected? At the core of these issues are fundamental rights. Let's explore them. First, the right to privacy under Article 31. This isn't just about secrecy. It's about control over your personal information. Filming or posting without consent reveals private affairs unnecessarily, eroding autonomy. Linked to this is Article 28, Human Dignity. Being exposed online can cause humiliation, affecting mental health and social standing. FIDE Kenya stresses that non-consensual sharing violates dignity and bodily autonomy. Under the DPA, data subjects have specific rights to be informed how data is used, access it, object to processing, correct inaccuracies, delete it. Right to be forgotten. And data portability. These empower individuals against misuse. Image rights, while not standalone, derive from property rights. Article 40. And privacy. Your likeness is yours. Internationally, Kenya aligns with UDHR Article 12 and ICCPR Article 17, protecting against arbitrary interference. These rights protect against exploitation, cyberbullying, and economic harm like job loss from viral shaming.in stories. Victims often face psychological harm, anxiety, depression. Rights ensure accountability, fostering trust in digital spaces. Which laws in Kenya govern this? Kenya's legal framework is robust. Key laws. 1. Constitution of Kenya, 2010. Articles 28, Dignity, 31, Privacy, 33, Expression, balanced with rights. 2. Data Protection Act, 2019. Regulates personal data processing. Principles. Lawfulness, minimization, accuracy. Requires consent, DPIs for high risk. ODPC enforces. Summary. Protects privacy per Article 31, C.D. 3. Computer Misuse and Cybercrimes Act, 2018. Criminalizes unauthorized access, sharing intimate images, Sections 37, 42. Fine/imprisonment. 4. Defamation Act. Related if posting defames, but privacy focus here. 5. Others. Films and Stage Plays Act for commercial filming. Copyright Act if using images commercially without rights. Evolution. Post-2010 Constitution, DPA addressed digital gaps. ODPC handles complaints, audits. Step-by-step guide, what to do if you're a victim in Kenya if you've been filmed or posted without consent, act fast. Here's a detailed step-by-step guide. Step 1. Document everything. Gather evidence, screenshots, URLs, dates, witnesses. Note emotional/financial impact for claims. Step 2. Demand removal. Contact the poster/platform. E.g., TikTok report button. Citing Kenyan laws. Many comply to avoid liability. Step 3. Report to ODPC. For data breaches, file via ODPC portal. Provide details, who, what, when. ODPC investigates within days, can order removal, fines. Free, online at odpc.go.ke. Step 4. Police report. If criminal, intimate images, harassment, visit station. Cybercrimes Unit. Get.ob number. Step 5. Seek legal aid. Consult lawyer/FIDA for civil suit, damages, injunction. High Court for constitutional petitions. Step 6. Support services. NGOs like FIDA offer counseling, ODPC for guidance. Step 7. Follow up. Track case, appeal if needed. Examples. In 2024, ODPC resolved 300+ cases with removals. Prevention, use privacy settings, educate. Remember, knowledge is power. If this helped, share it. Until next time, stay safe. But before you go, I just remembered something that happened recently. The case involving Vyacheslav Trahov, known online as Vyacheslav, a Russian national accused of secretly filming and sharing non-consensual videos of intimate encounters with women in Kenya, Ghana, and other African countries. Kenya has several avenues to support the victims. This incident, which gained viral attention in February 2026, highlights violations of privacy and consent, often captured via hidden devices like smart glasses and distributed on platforms such as TikTok, YouTube, and Telegram for profit. While Ghana has actively pursued extradition and offered direct victim support, Kenya's response has included calls for arrest and enforcement of local laws, but broader actions can and should be taken to aid those affected. Below, I'll outline key steps the Kenyan government and relevant authorities can implement, drawing from existing legal frameworks, institutional capabilities, and best practices for victim-centered responses. 1. Legal enforcement and prosecution. Kenya can prioritize investigating the case under domestic laws to hold the perpetrator accountable, which indirectly empowers victims by seeking justice. The Computer Misuse and Cybercrimes Act, 2018, criminalizes the unauthorized recording and distribution of intimate images, Section 37, with penalties including fines up to 200,000 Kenyan shillings or imprisonment for up to 2 years. Similarly, the Data Protection Act, 2019, DPA, treats videos as personal data requiring consent for processing, or violations can lead to fines up to 3 million Kenyan shillings or 10 years in prison. Immediate actions: the Directorate of Criminal Investigations, DCI, and its Cybercrimes Unit can launch a formal probe, gathering evidence from social media platforms via subpoenas or international requests. Reports indicate Kenyan authorities have already ordered Yetzeslav's arrest for filming without permission, which could involve tracking his whereabouts if he's still in the country or coordinating with immigration for deportation proceedings. International cooperation. If Yetzeslav has fled, as he reportedly did after Ghana, Kenya can request extradition through Interpol or bilateral agreements with Russia, mirroring Ghana's approach. The Ministry of Foreign Affairs could collaborate with counterparts in affected countries like Ghana for a joint effort. Victim benefits. Successful prosecution can result in court-ordered compensation for victims, including damages for emotional distress under constitutional rights to privacy, Article 31, and dignity, Article 28. 2. Content removal and digital protection. To mitigate ongoing harm from the videos circulating online, Kenya can facilitate rapid takedowns and prevent further dissemination. Role of the Office of the Data Protection Commissioner, ODPC. Victims can file complaints with the ODPC, which has the authority to investigate data breaches and order platforms to remove content. The government can escalate this by issuing directives to social media companies, e.g., Meta, TikTok, Telegram, under the DPA, requiring them to block or delete the material globally where possible. In similar past cases, ODPC has resolved hundreds of complaints leading to content removals. Collaboration with tech platforms. The Communications Authority of Kenya, CA, can work with international bodies like the Internet Watch Foundation to flag and de-index the videos from search engines. Victim support here. Providing free legal assistance to help victims navigate takedown requests, reducing their exposure and psychological trauma. 3. Psychosocial and medical support services. Many victims in such cases experience severe emotional distress, stigma, and health risks, e.g., from unprotected encounters, as alleged in some reports. Kenya can expand access to comprehensive care, counseling and mental health aid. The Ministry of Gender, Children, and Social Protection, similar to Ghana's model, can offer confidential counseling through national hotlines like the Gender Violence Recovery Center or partnerships with NGOs such as FIDE Kenya, Federation of Women Lawyers, and Amnesty International Kenya. These organizations already provide trauma-informed therapy for gender-based violence survivors, medical assistance. Free HIV testing, post-exposure prophylaxis, PEP, and STI screenings can be made available via public health facilities like Kenyatta National Hospital or county clinics, with priority for identified victims. The National AIDS Control Council could integrate this into awareness drives, shelter and protection, for victims facing backlash, e.g., from family or community. Temporary safe houses through the National Gender and Equality Commission, NGC, or women's shelters can be arranged. 4. Legal aid and compensation mechanisms. To empower victims in pursuing civil remedies, Kenya can subsidize or provide pro bono services. Free legal representation through the National Legal Aid Service, NLS, or bar associations. Victims can access lawyers to file suits for defamation, privacy invasion, or emotional damages. A Kenyan lawyer has publicly offered services in related divorce cases, but the focus should shift to victim support. FIDE Kenya, which specializes in women's rights, can represent victims in high court petitions for constitutional violations. Victim Compensation Fund. While not yet established specifically for cyber exploitation, the government could draw from the Witness Protection Agency or propose amendments to create a fund for digital abuse survivors, covering therapy, lost income, or relocation costs. 5. Prevention, awareness, and policy reforms. Beyond immediate help, Kenya can address systemic issues to prevent future incidents and build long-term resilience. Public awareness campaigns, the Ministry of Information, Communications, and Digital Economy can launch nationwide education on digital consent, privacy rights, and spotting hidden recording devices using media like radio, TV, and social platforms. This aligns with ongoing efforts by the ODPC to promote data literacy. Policy enhancements. Strengthen enforcement of the DPA by increasing ODPC's budget for monitoring and audits. Advocate for amendments to include harsher penalties for non-consensual intimate image sharing, inspired by global laws like the UK's Online Safety Act. Community engagement, partner with influencers, schools, and religious groups to destigmatize victims and promote safe behaviors, reducing victim blaming seen in online reactions.in summary. While Kenya has begun with arrest orders, it can do much more by leveraging its robust legal framework to provide holistic support. Legal, emotional, and preventive. To victims like those in this case. This not only aids recovery but also deters similar exploitation. If you're a victim or know one, start by contacting the ODPC hotline, odpc.go.ke, or FIDE Kenya for confidential guidance. Resources are available.